suffrage, political franchise, or simply franchise is the right to vote in public political elections. The right to run for office is sometimes called candidate eligibility, and the combination of both rights is sometimes called full suffrage. In many languages, the right to vote is called the active right to vote and the right to run for office is called the passive right to vote. In English, these are sometimes called active suffrage and passive suffrage. Suffrage is often conceived in terms of elections for representatives. However, suffrage applies equally to initiatives and referenda. Suffrage describes not only the legal right to vote, but also the practical question of whether a question will be put to a vote. The utility of suffrage is reduced when important questions are decided unilaterally by elected or non-elected representatives. In most democracies, eligible voters can vote in elections of representatives. Voting on issues by initiative may be available in some jurisdictions but not others. For example, while some U.S. states such as California and Washington have exercised their shared sovereignty to offer citizens the opportunity to write, propose, and vote on referendums and initiatives, other states have not. Meanwhile, the United States federal government does not offer any initiatives at all. On the other hand, many countries, such as Switzerland, permit initiatives at all levels of government. Suffrage is granted to qualifying citizens once they have reached the voting age. What constitutes a qualifying citizen depends on the government's decision. But most democracies no longer extend different rights to vote on the basis of sex or race. Resident aliens can vote in some countries, and other countries make exceptions for citizens of countries they have close links to. Etymology. The word suffrage comes from Latin suffragium, meaning vote, political support, and the right to vote. The etymology of the Latin word is uncertain, with some sources citing Latin suffragare, lend support, vote for someone. From sub, under, plus fragor, crash, din, shouts, related to franga, to break. Other sources say that attempts to connect suffragium with fragor cannot be taken seriously. Some etymologists think that it may be related to suffrager and may have originally meant an ankle bone or knuckle bone. Types. Universal suffrage. Where universal suffrage exists, the right to vote is not restricted by sex, race, social status, education level, or wealth. It typically does not extend a right to vote to all residents of a region. Distinctions are frequently made in regard to citizenship, age, and occasionally mental capacity or criminal convictions. The short-lived Corsican Republic was the first country to grant limited universal suffrage for all inhabitants over the age of 25. This was followed by other experiments in the Paris Commune of 1871 and the island Republic of Franceville. In 1893, New Zealand became the first major nation to practice universal suffrage, and the Freedom in the World Index lists New Zealand as the only free country in the world in 1893. In 1906, Finland became the second country in the world, and the first in Europe, to grant universal suffrage to its citizens. At this time, however, women in New Zealand did not have the right to run for office. In 1906, Finland became the first country in the world to give women full political rights. Women's suffrage. Women's suffrage is the right of women to vote on the same terms as men. This was the goal of the suffragists in the United States and the suffragettes in Great Britain. Short-lived suffrage equity was drafted into provisions of the state of New Jersey's first, 1776 Constitution, which extended the right to vote to unwed female landholders and black landowners. IV. That all inhabitants of this colony, of full age, who are worth £50 proclamation money, clear estate in the same, and have resided within the county in which they claim a vote for 12 months immediately preceding the election, shall be entitled to vote for representatives in council and assembly, and also for all other public officers. that shall be elected by the people of the county at large, New Jersey 1776. However, the document did not specify an amendment procedure, and the futile provision was subsequently replaced in 1844 by the adoption of the succeeding constitution, which reverted to all-white male suffrage restrictions. Limited voting rights were gained by some women in Sweden, Britain, and some western U.S. states in the 1860s. In 1893, the British colony of New Zealand became the first self-governing nation to extend the right to vote to all adult women. In 1894, the women of South Australia achieved the right to both vote and stand for Parliament. The autonomous Grand Duchy of Finland in the Russian Empire was the first European nation to allow all women to both vote and run for Parliament. Equal suffrage is sometimes confused with universal suffrage, although its meaning is the removal of graded votes, where a voter could possess a number of votes in accordance with income, wealth or social status. Census suffrage, also known as censorship suffrage, the opposite of equal suffrage, meaning that the votes cast by those eligible to vote are not equal, but are weighed differently according to the person's rank in the census. Suffrage may therefore be limited, usually to the propertied classes. Compulsory suffrage. Where compulsory suffrage exists, those who are eligible to vote are required by law to do so. 32 countries currently practice this form of suffrage. Business vote. In local government in England and some of its ex-colonies, businesses formerly had, and in some places still have, a vote in the urban area in which they paid rates. This is an extension of the historical property-based franchise from natural persons to other legal persons. In the United Kingdom, the Corporation of the City of London retains business votes, as the City of London is a major financial centre with few residents. The first issue of the Northern Ireland civil rights movement was the business vote, abolished in 1968. In cities in most Australian states, voting is optional for businesses but compulsory for individuals. Forms of exclusion from suffrage. Religion. In the aftermath of the Reformation, it was common in European countries for people of disfavored religious denominations to be denied civil and political rights, often including the right to vote, to stand for election or to sit in Parliament. In the Great Britain and Ireland, Roman Catholics were denied the right to vote from 1728 to 1793, and the right to sit in Parliament until 1829. The anti-Catholic policy was justified on the grounds that the loyalty of Catholics supposedly lay with the Pope rather than the national monarch. In England and Ireland, several acts practically disenfranchised non-Anglicans or non-Protestants by imposing an oath before admission to vote or to stand for office. The 1672 and 1678 Test Acts forbade non-Anglicans to hold public offices. The 1727 Disenfranchising Act took away Catholics' voting rights in Ireland, which were restored only in 1788. Jews could not even be naturalized. An attempt was made to change this situation, but the Jewish Naturalization Act 1753 provoked such reactions that it was repealed the next year. Nonconformists were only allowed to run for elections to the British House of Commons in 1828, Catholics in 1829, and Jews in 1858. Benjamin Disraeli could only begin his political career in 1837 because he had been converted to Anglicanism at the age of 12. In several states in the U.S., after the Declaration of Independence, Jews, Quakers or Catholics were denied voting rights or forbidden to run for office. The Delaware Constitution of 1776 stated that every person who shall be chosen a member of either House or appointed to any office or place of trust, before taking his seat, or entering upon the execution of his office, shall also make and subscribe the following declaration, to wit, I, A.B. do profess faith in God the Father, and in Jesus Christ his only Son, and in the Holy Ghost, one God, blessed forevermore, and I do acknowledge the Holy Scriptures of the Old and New Testament to be given by divine inspiration. This was repealed by Article 1, Section 2 of the 1792 Constitution. No religious test shall be required as a qualification to any office, or public trust, under this state. The 1778 Constitution of the State of South Carolina stated that no person shall be eligible to sit in the House of Representatives unless he be of the Protestant religion. The 1777 Constitution of the State of Georgia that the representatives shall be chosen out of the residents in each county and they shall be of the Protestant religion. In Maryland, voting rights and eligibility were extended to Jews in 1828. In Canada, several religious groups were disenfranchised by the Wartime Elections Act of 1917, mainly because they opposed military service. This disenfranchisement ended with the end of the First World War, but was renewed for do-overs from 1934 to 1955. The first constitution of modern Romania in 1866 provided in Article 7 that only Christians could become Romanian citizens. Jews native to Romania were declared stateless persons. In 1879, under pressure of the Berlin Peace Conference, this article was amended granting non-Christians the right to become Romanian citizens. But naturalization was granted on a case-by-case basis and was subject to parliamentary approval. An application took over 10 years to process. Only in 1923 was a new constitution adopted, whose Article 133 extended Romanian citizenship to all Jewish residents and equality of rights to all Romanian citizens. In the Republic of Maldives, only Muslim citizens have voting rights and are eligible for parliamentary elections. On 25 November 2011, the UN Human Rights Chief called on Maldivian authorities to remove the discriminatory constitutional provision that requires that every citizen be a Muslim, wealth, tax class, social class until the 19th century. Many Western proto-democracies had property qualifications in their electoral laws, e.g., only landowners could vote, or the voting rights were weighed according to the amount of taxes paid. Most countries abolished the property qualification for national elections in the late 19th century, but retained it for local government elections for several decades. Today these laws have largely been abolished, although the homeless may not be able to register because they lack regular addresses. In the United Kingdom, until the House of Lords Act 1999, peers who were members of the House of Lords were excluded from voting for the House of Commons because they were not commoners. In Britain and some other monarchies, the sovereign is ineligible to vote in parliamentary elections. Knowledge. Sometimes the right to vote has been limited to people who had achieved a certain level of education or passed a certain test, e.g., literacy tests. In some states of the U.S., race. Various countries, usually countries with a dominant race within a wider population, have historically denied the vote to people of particular races, or to all but the dominant race. This has been achieved in a number of ways. Official laws and regulations passed specifically disenfranchising people of particular races. Indirect. Nothing in law specifically prevents anyone from voting on account of their race, but other laws or regulations are used to exclude people of a particular race. In southern states of the United States of America before the passage of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, poll taxes, literacy and other tests were used to disenfranchise African Americans. Property qualifications have tended to disenfranchise a minority race, particularly if tribally owned land is not allowed to be taken into consideration. In some cases this was an unintended consequence. Unofficial. Nothing in law prevents anyone from voting on account of their race, but people of particular races are intimidated or otherwise prevented from exercising this right. In New Zealand, the Maori have been enfranchised effectively since 1865 at the conclusion of the Maori War. Maori still have the choice of voting in a general electorate or a solely Maori electorate. Age. All modern democracies require voters to meet age qualifications to vote. Worldwide voting ages are not consistent, differing between countries and even within countries, usually between 16 and 21 years. Many voting would extend voting rights to everyone including children regardless of age. The movement to lower the voting age is known as the Youth Rights Movement. Criminality. Many countries restrict the voting rights of convicted criminals. Some countries, and some U.S. states, also deny the right to vote to those convicted of serious crimes, even after they are released from prison. In some cases the denial of the right to vote is automatic on a felony conviction. In other cases deprivation of the vote is meted out separately, and often limited to specific crimes such as those against the electoral system or corruption of public officials. In the Republic of Ireland, prisoners are allowed the right to vote, following the Hearst v UK ruling, and this was granted in 2006. Canada allowed only prisoners serving a term of less than 2 years the right to vote, but this was found unconstitutional in 2002 by the Supreme Court of Canada in Sauvé v. Canada, and all prisoners were allowed to vote as of the 2004 Canadian federal election. Residency. Under certain electoral systems, elections are held within subnational jurisdictions, preventing persons who would otherwise be eligible from voting because they do not reside within such a jurisdiction, or because they live in an area that cannot participate. In the United States, residents of Washington, D.C. receive no voting representation in Congress, although they have full representation in presidential elections. Residents of Puerto Rico have neither. Sometimes citizens become ineligible to vote because they are no longer resident in their country of citizenship. For example, Australian citizens who have been outside Australia more than 1 and less than 6 years may excuse themselves from the requirement to vote in Australian elections while they remain outside Australia. Danish citizens that reside permanently outside Denmark lose their right to vote. In some cases, a certain period of residence in a locality may be required for the right to vote in that location. For example, in the United Kingdom up to 2001, each 15th of February a new electoral register came into effect, based on registration as of the previous 10th of October, with the effect of limiting voting to those resident 5 to 17 months earlier depending on the timing of the election. Nationality. In most countries, suffrage is limited to citizens and, in many cases, permanent residents of that country. However, some members of supranational organizations such as the Commonwealth of Nations in the European Union have given voting rights to citizens of all countries within that organization. Until the mid-20th century, many Commonwealth countries gave the vote to all British citizens in the country, regardless of whether they were normally resident there. In most cases this was because there was no distinction between British and local citizenship. Several countries qualified this with restrictions preventing non-white British citizens such as Indians and British Africans from voting. Under European Union law, citizens of European Union countries can vote in each other's local and European Parliament elections on the same basis as citizens of the country in question, but usually not in national elections. Naturalization. In some countries, naturalized citizens do not have the right to vote or to be candidate, either permanently or for a determined period. Article 5 of the 1831 Belgian Constitution made a difference between ordinary naturalization and grande naturalization. Only foreigners who had been granted grande naturalization were entitled to vote, be a candidate for parliamentary elections, or be appointed minister. However, ordinary naturalized citizens could vote for municipal elections. Ordinary naturalized citizens and citizens who had acquired Belgian nationality through marriage could vote. but not be candidates for parliamentary elections in 1976. The concepts of ordinary and grande naturalization were suppressed from the Constitution in 1991. In France, the 1889 nationality law barred those who had acquired the French nationality by naturalization or marriage from voting, eligibility and access to several public jobs. In 1938 the delay was reduced to 5 years. These discriminations, as well as others against naturalized citizens, were gradually abolished in 1973 and 1983. In Morocco, a former French protectorate, and in Guinea, a former French colony, naturalized citizens are prohibited from voting for 5 years after their naturalization. In the Federated States of Micronesia, one must be a Micronesian citizen for at least 15 years to run for parliament. In Nicaragua, Peru and the Philippines, only citizens by birth are eligible for being elected to the national legislature. Naturalized citizens enjoy only voting rights. In Uruguay, naturalized citizens have the right of eligibility to the parliament after 5 years. In the United States, the president and vice president must be natural-born citizens. All other governmental offices may be held by any citizen, although citizens may only run for Congress after an extended period of citizenship. Function in France. An 1872 law, rescinded only by a 1945 decree, prohibited all army personnel from voting. In Ireland, police were barred from voting in national elections, though not local elections, from 1923 to 1960. The 1876 Constitution of Texas stated that the following classes of persons shall not be allowed to vote in this state, to wit: Fifth, all soldiers, marines and seamen, employed in the service of the Army or Navy of the United States. In many countries with a presidential system of government, a person is forbidden to be a legislator and an official of the executive branch at the same time. Such provisions are found, for example, in Article 1 of the U.S. Constitution.